Hi, my name is Sonia Pierkin. I am an immigration attorney, and today we're going to discuss why visitors' visas are denied. So, visitors' visas are visas that are issued either for business purposes or for pleasure. And you can also get a combination visa, B1, B2, that allows both pleasure and business. So when you apply for any visa, you have to prove eligibility. One reason why your visitor visa may be denied is if you're not able to prove sufficiently to the immigration officer that you have significant ties in your home country. Significant ties help to establish that you are only going to enter the United States for a temporary reason for purposes allowed by your visa and then leave before your authorized stay expires. It's really important for the officers to be convinced that you really are going to just come for that purpose and leave within before your stay expires, because our U.S. government assumes that all non-immigrants have immigrant intent. What that means is that even people who are applying for temporary visas, our U.S. government assumes that they really intend to stay permanently. And so it is your job to prove them wrong. It's your job to overcome that assumption with evidence through your testimony and through documentary evidence. Ways that you can prove significant ties is through employment, family ties in your home country, owning property and managing property in your home country, and other obligations in your home country. So once you do that to the satisfaction of the officer, then you will overcome that particular requirement for the visa. Now, also keep in mind that this part of the visa process, proving that you really don't have immigrant intent or intent to stay permanently in the United States, there's so much discretion involved here when the officer reviews the evidence and reviews your testimony to decide whether they're convinced that you really intend to stay temporarily and leave. And so you will find that sometimes the way that these visas are adjudicated are not always fair, and it's not always consistent because there's so much discretion involved. The other thing that may also work against you is if you have close family members in the United States. Close family members in the United States may indicate to that officer that you really intend to reunite with your family members and to stay permanently in the United States as opposed to just visiting and leaving. This is especially so when you have a U.S. citizen spouse or a U.S. citizen boyfriend or girlfriend. And also keep in mind that those questions will be asked of you when you are applying for your visa, because it's one of the things that they consider when approving these types of visas. The other reason why your visa may be denied is if you have lied on your application or committed fraud. So if you lie on your application about your criminal background, your immigration history, the family members that you have in the United States, if you lie on your application may be denied. It's always best to be truthful, provide honest answers to questions on your application and during the interview. Because if you're caught in a lie, the consequences are very significant. It may be harder for you to overcome and create more issues for you in the future. Another reason why your visa may be denied is if you have committed certain crimes. So your criminal history will be examined whenever you're applying for a visa into the United States. So they want to make sure that you're not going to become a threat to society or create a public safety issue. If you have certain convictions, these convictions may make you inadmissible. Inadmissible means that you do not qualify to enter the United States and you don't qualify for a visa. So certain convictions, although they make you inadmissible, may be waivable. So you may apply for a waiver, which is basically a request to the government to enter the United States despite having committed that crime. So if that waiver is approved, then you will be able to continue the process. Not all convictions are waivable, and not all convictions require a waiver. So it's really important that if you do have criminal history, you should consult with an immigration attorney and have your criminal history carefully examined so that you understand what kind of consequences it will have for your visa application, and then you can come up with a strategy to see whether a waiver is possible, and what the process is to go about doing that. Another reason why your visa may be denied is your immigration history. So if you have a history with immigration that involves deportation or overstaying your visa or violating your visa, then you may also be inadmissible or ineligible for any visa, and you may need to look into whether you can waive your inadmissibility ground by filing a waiver and having that approved. Now, if you've overstayed a visa for 180 days or longer, you may have triggered either a 3 or 10-year bar if you left the country. So with triggering a 3 or 10-year bar, that means that you would not be able to enter the United States on a visa during that time. But there are ways that you may be able to waive that bar or have that bar lifted through a waiver process. And so if you have committed or violated certain immigration laws in the past, you should consult with the immigration attorney to see what can be done about that, or if there are ways to lift your inadmissibility bars to allow you to continue your visa process. If you are looking to obtain a visa to enter the United States or to immigrate to the United States, you can contact me to discuss your case in detail at 321-325-1125, or you may visit me at www.sapeterkinlaw.com. Thanks for watching, and subscribe to my channel below.